Good morning and welcome to our March webinar for PERB. This month's webinar is going to be an overview of SMCS mediation services. My name is Jerry Fetcher. I'm the director of the California State Mediation and Conciliation Service, and we are a division of the Public Employment Relations Board. Our agenda for today, we're going to do an introduction and ask what is SMCS, and then we'll talk about mediation. What is it? We will talk about contract negotiations mediation and give you some details about that process. And then we will talk about grievance mediation and then conflict resolution for the workplace mediation. And finally, how to request SMCS mediation services. Please note the views expressed in this presentation are those of the presenter and are not PERB's official position on any matter. This content is for general informational purposes only. This information is not legal advice. Some statutes PERB administers have unique characteristics that may differ from the general principles discussed here. Please refer to those specific statutes, regulations, precedential decisions, or other legal authorities as appropriate. You can send questions about this material or PERB's process to our email address, which is perbquestions@perb.ca.gov. That's PERBQUESTIONS@perb.ca.gov. Introduction. What is SMCS? The California State Mediation and Conciliation Service, or SMCS, is a division of the Public Employment Relations Board, PERB. SMCS was founded in 1947 and at first conducted only private sector mediation throughout the state. The Federal Mediation and Conciliation Service was founded in the same year, and we shared the caseload with them in the private sector. Transit districts then were some of the earliest employees to be granted the right to unionize in the 1950s in the public sector, and SMCS had jurisdiction over those employers and employees. These were largely done under public utility code statutes, and there was a statute for each transit district that was given the right to unionize. And so SMCS got a lot more involved in doing public sector mediation and assisting these transit districts and their employers with their contracts. Then in 1968, we had the Myers-Milius-Brown Act, or MMBA, which expanded the right to unionize in the public sector to cities, counties, and to special districts such as water districts or healthcare districts. And SMCS expanded its services to MMBA employees and employers. So we were able to provide mediation services. This was before PERB was founded, so our mediation service was under the Department of Industrial Relations. We also conducted representation elections for Myers-Milius-Brown jurisdictions. Then you had the Educational Employment Relations Act in 1976, which granted the rights to unionize to employees of K-12 school districts and community colleges. And SMCS provided mediation services to these employees. Related to this statute, PERB was actually founded to administer other aspects of the statute, such as unfair labor practices and representation matters. But at this point, SMCS would provide the mediation services when the school districts were at impasse. And we still remained under the Department of Industrial Relations, but we provided mediation services to school districts. And then in 1977, the DILS Act was passed, which expanded public sector unionizing to employees of the state of California. And then it was followed by the Higher Education Employee Relations Act in 1979, which expanded the rights to unionize to employees of the University of California, or UC systems, and the California State University, CSU systems. And SMCS, as you could guess, was involved in expanding our jurisdiction to mediation for all of those employees as well too. So when there was an impasse in negotiations, or there were grievances that needed to be mediated, which we'll get into shortly, SMCS was the agency for these employees to go to, and the employers. In 2012, we became a division of PERB, given that SMCS by then conducted almost all of our mediation and representation services in the public sector. By this point, our private sector work was very limited to where we were already listed in contracts, or we had continually worked with the parties. It was a very minor amount of work that we were doing in the private sector. However, in 2025, that changed. We took on additional private sector mediation work due to reductions in service in the Federal Mediation and Conciliation Service, or FMCS. Currently, as I speak, we will provide all grievance mediation services to private sector unions and their employers in California, as well as for any bargaining unit that is less than 250 for contract negotiations mediation. We currently do not, currently the Federal Mediation and Conciliation Service is providing services for mediation for contract negotiations for healthcare districts of any size. So that might be subject to change, but it has resulted in SMCS taking on more work, and we've been able to do that for our constituents because we were originally constituted under the law to provide mediation for any sort of public or private sector constituents. And then the next item that we have is mediation. What is it? Now, I'll give you the legal definition, and we'll get into a little bit more of a explanation about what that is. Mediation is a confidential and non-adjudicatory process that includes a neutral third-party mediator and which emphasizes compromise and collaboration towards settlement. Now, confidentiality is the first part of that we mentioned in here. Confidentiality is a cornerstone of the mediation process. It means that the discussions that go on, whether they're in a mediation setting with the mediator and both parties there, or the mediator is in a caucus room with one side or another, everything, including what the mediator, all participants it has to remain confidential, and that's under the California Evidence Code. It allows the parties to have a frank and open discussion to try to resolve the matter, if it's a contract negotiations issue or if it's a grievance. And so then what does non-adjudicatory mean? It's a bigger legal type word. It means that the mediators are not there to be making a decision, like an arbitration where the person acts in an adjudicatory role. They're actually acting as a judge, or if you're going through PERB on an unfair practice, it can ultimately result in an administrative law judge making a determination. Our mediators are there to work with the parties to facilitate a settlement, but we're not there to ultimately make a decision. So we're going to be running it slightly different than an evidentiary hearing. Of course, we need to know what the matter is regarding, and we need to be educated on the issues because we're coming in as a new neutral third party. But ultimately, we're not there to make a decision for the parties. Mediation can be conducted in person, or since COVID happened, we can be on a secure video conference platform. And so we have all of the latest technology to facilitate that. So we can do both in person or in video conference platform. Our in-person mediations, rather than to come to one of the PERB offices, we go out to your chosen location, be that whether it's a union office or the employer, a school district office, or city hall. We'll come out there. And it's important to emphasize that all of our core services that I'll mention are free of charge to the parties. I'll delineate the one exception that we have later in this presentation. And our SMCS mediators, you might be wondering, who are they? Well, they are all people who have worked in either labor, management, or both in the public sector in California and have a wealth of experience with regard to labor relations. And so they are now neutrals, and they are experienced and able to use their experiences to assist the parties in coming to a settlement. And they come from a diversity of backgrounds and industries as well, too, throughout the state. Now we'll break it down to types of mediation. The contract negotiations mediation is the one that probably you hear the most of in the press and everything like that too. It's where the parties are in contract negotiations, and they're wanting to bring in a third-party mediator who's a neutral to assist them because they're at a logjam or an impasse. That's the first thing I'll mention here. Impasse mediation is the most common type of contract negotiations mediation. Now, this can differ depending on what jurisdiction you're in by statute. But the contract negotiations mediation, most common one, as I mentioned, is impasse mediation. That's where the parties are either formally at impasse or they declare impasse depending on the statute. And so typically we will be contacted by either the parties, or if it's a school district or higher education, PERB will certify it as impasse and will ask us to appoint a mediator. In impasse mediation, the mediator will, again, either will be on a video platform or will come out to your location, and we'll have both negotiating committees and the mediator. Sometimes we'll have more than one mediator depending on the type of case that it is, but most of the time the mediator will travel out to your location and will meet and work with the parties, usually over several sessions, because in most contract negotiations mediations, there are a number of issues that are in dispute between the parties. We'll get to grievance mediation in a bit, where there's usually a single issue or maybe one or two issues that have to be dealt with. The one thing that I'll mention next is pre-impasse mediation. Pre-impasse mediation, a lot of our constituents don't realize that if you're getting stuck on a particularly hard contract negotiations matter, that you can contact us. If both parties agree, we can send a mediator in their pre-impasse mediation. So before maybe it's formally declared as an impasse, or you have a particularly knotty issue that you want to have us address, we can send in the mediator. We'll be happy to do so. So that is something that people don't always realize that we can do. And then we also have post-impasse mediation, which a lot of times too, there's depending on the statute, when mediation has closed and it didn't result in a settlement, it can sometimes go on to fact finding depending on your jurisdiction, or it goes on to it remains unresolved. And we can come in at any point, and you can contact it if the parties agree. We can come in there. A lot of times, post-impasse mediation is where the matter is usually could be heading towards a work stoppage or strike. So we encourage the parties to do that, even if the initial mediation didn't result in a settlement. We encourage the parties to try and bring in a third-party mediator at that stage of the process as well, too. We also can do a facilitation type of mediation. Now, this is similar to pre-impasse. It usually happens pre-impasse, but a lot of times too with contract, if you anticipate you're going to have a difficult cycle of contract negotiations, we can come in earlier and act as a facilitator. Not necessarily we're trying to find common issues that the parties have and pathways to settlement, but we can it's a lighter form of mediation, but we can come in. Usually it's at the earliest stage of your process, and so the mediator can help facilitate and move the parties towards a settlement. The other type that we have that's more of a formal based facilitation process is called interest-based bargaining, or IBB. Interest-based bargaining is a type of mediation or a type of process where the parties, it's not necessarily mediation, but it's a type of process where the parties identify their issues rather than have the traditional hard bargaining where you have 18 proposals and you're going back and forth. You talk about what your interests are on both sides, and our mediators are trained in doing that unique part of mediation. So if your traditional mediation your traditional bargaining isn't working, interest-based bargaining can be an option that you have. And since we're limited on time, I won't get into the full detail, but if you have more questions on that, you can always contact us. And then single issue mediation is very similar to grievance mediation, although usually it's as a result of some change that has happened, maybe in a regulation or a policy, where the parties have to bargain over it. So we can come in on that as well too. A lot of times this is when you're within a contract and there's an issue that has happened in between the contract, and like I said, some type of change, some type of regulation that has occurred where or a law statute has passed where the parties have to address it in terms of maybe there's a higher staffing requirement, and how is that going to be done? So that's another thing that we can come in, and it's very similar to a grievance mediation, but a grievance mediation is per your process in the contract. And speaking of which, our next subject that we're going to be talking about is grievance mediation. And as I mentioned, mediation can be a required part of the grievance procedure. Sometimes it's not. Sometimes it's listed in your contract. Other times it's not. If it's not listed in your contract, as long as both parties agree, we don't need any formal, a form to be filled out or anything. You can contact us, and we'll send a mediator out to mediate that. Sometimes if it's not listed in your contract, and most of the time it's you can settle it if you have a grievance that you are having difficulty settling. We'll always be happy to send out a mediator to do that. And the types of grievance mediation that you usually will come across where we can assist the parties are there's two types. Disciplinary is the first one I'll talk about. That's where typically an employee or employees have been disciplined or discharged, and the union is filing a grievance on their behalf. And also in the public sector, in some cases, the employee can file it on their behalf as well too. So sometimes they're self-represented. So we can come in and mediate those and work with the parties to settle that. Short of typically the grievance procedure will end, in most cases, depends on your individual contract, but it will end in an arbitration, which ultimately will result in a decision from a third party arbitrator. But this is the step before that. So a lot of times it's good to have a third party where we don't have any stake in the outcome to come in and help the parties come to a settlement, short of having it go to arbitration where a final decision will be issued. The other type of grievance mediation that we'll have is contract interpretation mediation, and that's usually depending on a particular provision of a contract and whether that has been violated and what's the interpretation of it. A lot of times it depends on the language as to whether maybe somebody should receive an upgrade and have they reached that threshold, and the parties are in disagreement on that. And then the mediator, we can come in and work with the parties and use our experience in working with contract language to help the parties. So, again, arbitration would be the last step of the grievance procedure. And you want to have at least, even if the parties are kind of set in their ways, it's always good to have it presented to a third party, because ultimately, even if it doesn't result in it, I, as somebody who has practiced before in front of a mediator, have learned a lot of times about issues that we have in the case, and maybe we have weaknesses that we didn't see, or strengths that we have as well too. And a lot of times it can ultimately result in, even if it doesn't result in a settlement, it results in having a better understanding about your case. And then mediation, as I mentioned before, sometimes it's required under contract, so it's a required step of the procedure, and we're cognizant of that. Sometimes the parties, you're set in your ways, and there's no way that you can bridge the gap. But at the same time, we still think it's helpful to work towards that for the reasons I just mentioned earlier, where sometimes you will come across a situation where you didn't anticipate certain arguments in the case as well too. And then, like I mentioned before, it can be requested by mutual consent of the parties. We don't require a form to be filled out or any type of or that it has to be part of listed in your contract as a step in the procedure. We merely, if the parties want our help, we'll send a mediator out to help you with that, with grievance mediation. And the final type of mediation that I'll be talking about today is conflict resolution for the workplace mediation. Now, I will say this is the only fee-based mediation service that we have from SMCS. And this is a lot different from the other types of mediation I mentioned. This is a mediation between two employees or among a group of employees or managers. And this is typically done in the public sector with agencies where we're contacted and there are issues between employees. So this is outside of a union and an agency mediating. This is a different type of mediation that we started in 2010 at SMCS. And so it ends up being a contract type matter where SMCS can contract with your agency to resolve issues that are affecting morale, productivity, and attendance in the workplace. And if you want more information on that, we have more information on our website, as well as you can contact us if you have questions about that. But a lot of times this is where it doesn't have, it's a different style of mediation, and our mediators are trained to be able to do that type of mediation for you as well too. And like I said, keep in mind this is a different type of mediation, and all of the rest of our services are free of charge to the parties, minus our arbitration list, which is not a type of mediation. And then how to request SMCS mediation services. To initiate mediation, one or both parties should contact SMCS using one of the following methods. And like I said, we don't have any form to fill out, but this is the information that's most helpful that we would need. But you can contact us by email at smcsinfo@perb.ca.gov, or by phone at 916-322-7638. Or if you want to go old school, we still have fax. You can contact us there at 916-327-7955. And in that correspondence, please include the following. This is really helpful for me when I'm assigning the cases: the name of the employer, the name for the employer's representative, contact information, phone number, and email. Also the name of the employee organization or union, then the name for the employee organization or union's representative, the contact information such as phone number or email. And then also too, if you could specify the type of mediation needed, be that a grievance, an impasse, or the other types that I mentioned. And if you have any questions about the type of mediation, you can always give us a call and be happy to discuss that and what services that we can provide in that regard. And this concludes our overview of the Division of State Mediation and Conciliation Service and the services that we provide. If you have additional questions, feel free to access the statutes that PERB administers, PERB's regulations, and presidential board decisions on PERB's website, which is www.perb.ca.gov. And you can access specifically the State Mediation and Conciliation Services at www.perb.ca.gov/STATE-MEDIATION. That's for state mediation. And a lot of the information that we provided on here is on that site as well too. And specifically, you can send questions to us about SMCS and our services to smcsinfo@perb.ca.gov. I want to thank all of you for joining us today and learning more about State Mediation and Conciliation Service. It's been a pleasure to spend time with you today, and I'd be happy to answer any of your questions in the future. I hope that all of you have the best luck and results in your labor relations, but if you need us, we're happy to come and assist you. And then please join us on April 17th for our next webinar about preparing for formal hearings before PERB administrative law judges. Thank you, and have a good rest of your day.